I am Ezinne Emanuela, and in today's video, let's talk about ownership of copyright. For ownership of copyright to arise, first, there must have been an author who expressed his creativity either in a literal, artistic, musical, or audiovisual form, right? The person must have expressed his intellect in a fixed medium. It does not matter whether the person is creative enough. What matters is that so long as the person perspires to create that work, he is the author. At this point, it is paramount to differentiate between an author and an owner of a work. Who is an author? Who is the owner? An author is that person that expresses his idea towards the creation of a particular work, while the owner is that person who exploits the work, that is the financial aspect of it, who exploits the work, right? Authorship is measured on the moral rights, which include the right to be identified as the author of such work, even the right to object to its extortion and mutilation. While ownership has to do with the economic rights, that is the financial aspect, which include the right to reproduce, the right to publish, to distribute, and to financially exploit the work. Copyright ownership, the aim of copyright ownership is to protect creativity and to avoid third parties from exploiting from the work. Imagine, like, if you go to Facebook, even in this YouTube app, you will see some people who downloads other people's video and post. They are making money from it. They might even be making more than the person that created the work. That is an infringement in the copyright of that other person, right? So, as a law student, not just a law student, as anyone, it is paramount that you have the knowledge of copyright infringement because the matter can arise at any time. We might be a victim, right? So, first, ownership of copyright. According to Section 28, Sub 1 of the Copyright Act 2022, the author is the first owner of copyright. The author is always regarded as the first owner of copyright. But there are circumstances whereby the author might not be the owner. It's funny, right? Laugh with me. So let's take for instance that I am creative enough, right? But then I don't have the money to reproduce or to create this, like to publish this work, right? Like I am creative enough that I can put down a piece of material, but I don't have the money. Someone might employ me, pay me, and we have an agreement that any work I create, that he is the owner, right? In these circumstances, I am the author, but am I the owner? No, he is the owner, right? So this principle is significant in employer-employee relationship. You know, the law respects people's creativity, right? So this principle is very important in employer-employee relationship. It simply states that when an employee creates a work in the course of his employment, the ownership in that work belongs to the employee, except with the contrary agreement of the both parties. You know, the court respects parties' agreements, like it bows down to it. Not even the court can inquire into parties' agreements. It respects parties' agreement. So, in a situation whereby someone employ you and in your employment contracts, it is written that anything, any work created in the course of this employment, that its ownership shall vest on the employer, then the law will respect that, right? In the case of Joseph Korea versus Campaign Service Limited, it was held that although the work was created in the course of the employment. Since the party has the agreement contrary to that, then ownership in that copyright vests in the employer, right? So it is very, very paramount that we have the knowledge of this. Ownership of copyright by the government. According to Section 22, Sub 2 of the Copyright Act 2022, ownership of copyright vests in the government where the work is created, except with the contrary agreement of the parties. I like this agreement very well, right? So shine your eyes when you are entering into um, an agreement with somebody, or maybe someone else employs you. Shine your eyes on the things you agree on, right? So it vests on the government, except with the contrary intentions of agreements of the parties. But then the court has laid down the test in determining when a work would fall under the cost of employment of someone. In the case of Bain versus Tatis and Co., the court will inquire whether that particular work fall within the official duty of the employee, whether it was created during the working hours or in the premises of the employer, whether the materials and facilities used in the creation of the work belongs to the employer, and whether the work was done at the request of the employer, right? That is the test in determining whether a work was created in the course of the employment. If these principles are established, then the ownership in the copyright will vest in the government. Then, the major difference between authorship and ownership is that authorship is permanent; it cannot be transferred, while ownership can be transferred either by agreements, by license, which could be exclusive or non-exclusive license, by the operation of law. These are the ways that someone can actually transfer ownership of copyright to another, right? Please do me a favor, like this video, subscribe to this channel, and drop the topic you would want me to handle in the comment section. Thank you. Bye bye.